The DC high heel race was last night, and whoever had Stephen Miller in the pool, I owe you a Coke. That wig was hideous, but old girl could run in them heels. Hegseth unfortunately never made it out of the bar, so we didn't get to see old Pete run, but I'm told she was quite the center of attention in that lace front and just chewing up the scenery all night at JR's. Happy Wednesday, everybody. I'm Brino, and this is the Morning Report on the federal courts for October 28th, 2025. Do me a favor, double tap your screen, comment what you're heading out for Halloween, and watch the first minute right now, even if you're coming back later, so we hit the FYP. Consider subscribing or becoming a member to support my work if you like what I'm doing. All right, let's get to some court news, shall we? Let's go. All right, we're going to start with the biggest news. I think the Ninth Circuit has agreed to rehear the Oregon v. Trump case en banc and have vacated the decision of the three-judge panel from earlier last week. That means that the entire Ninth Circuit, all 29 judges, have voted and decided that they didn't like the opinion, and now 11 of them, I think, will rehear it and make a new decision. The question up in the air is whether the president could nationalize and deploy the National Guard in Oregon, and the three-judge panel said he could. Sort of. That's not exactly what they said, but it doesn't matter now because it's vacated. Now, the announcement from the Ninth Circuit had very little information. It was 4 lines, basically 2 sentences, but there may be one interesting factor that could have played in. So one of the reasons cited by the majority in that three-judge panel for its decision was that protests in Oregon had forced redeployment of 115 Federal Protective Service officers, nearly 25% of all FPS officers nationwide. And that fact was heavily relied upon in the 2 majority judge opinions, even though the dissent noted that the language seemed a little squirrely. Well, on Wednesday, the plaintiffs in the case got hold of some new discovery from the government that showed that, in fact, the highest number of FPF officers Portland ever saw was 31. And that was only for a brief time in July. In other words, there may have been some stretching of the facts. And so the plaintiffs provided this information to the Ninth Circuit as they deliberated over whether or not to rehear this case. Did this factor in? Who knows? But it may have. Now, en banc hearings in the Ninth Circuit don't happen very often. According to the circuit, they get about 1,500 requests a year and hear about 15 to 25 of them. So this is rare, and in my experience, they don't happen fast. Often they take months to schedule, but this one might happen a little faster because of, the nature of the filing and all the attention on the case. I'm not sure. We also know that the Supreme Court has been asked to stay a nearly identical decision by the Seventh Circuit in Chicago. So will they want to hear what the Ninth Circuit has to say first? I don't know. All right, and if you thought that was all, buckle up, kids, because this morning, the original district court case starts its trial. See, all of this stuff was about a temporary restraining order. So now the judge is going to decide the longer preliminary injunction and is just going to go ahead and roll it into a trial on the merits under Rule 65A2, for those of you who are CivPro geeks. So that will be a 3-day trial that could make a lot of these questions moot, and it starts this morning. We're in a holding pattern again, but at least we now know where the planes are, so that's good. All right, next we will check in on Chicago Headline Club. Now, I would have given my right foot to be in the courtroom yesterday and hear what happened for myself, but I do not have ticket to Chicago money at the moment, so I gotta rely on secondhand accounts. Customs and Border Patrol Commander Gregory Bovino was ordered to appear in front of Judge Ellis to answer allegations that officers under his command have violated the terms of her TRO, and he did so yesterday. And for the record, I am not hearing any reports that he was rude or combative, and actually from what I've gathered so far, it seems like he was direct, answered the question, and even worked with her to find some workable solutions. So, a few important takeaways. Judge Ellis really tore into him over the fact that children on their way to a Halloween parade were tear-gassed on Saturday. Quote, "I can only imagine how terrified they were. These kids, their sense of safety was shattered on Saturday, and it's going to take a long time for that to come back." She reminded Commander Bovino, after he said the other day that he only takes orders from the executive branch, that he has sworn an oath to support and defend and uphold the Constitution just like her. And she said she was there to see that he and the agents under you, quote, "are acting in a manner that is consistent with your obligations under the law." So, she walked through the TRO line by line with the commander and reminded him that he has to follow it. And it sounds like they also worked out some kinks together, like they picked some workable spots for identification that would be appropriate regardless of, different uniforms people might be wearing, but that would be visible on camera. She also asked about body cameras. He said that every single one of the 200 or so CBP officers in Chicago was capable of wearing one, but not everyone was, including himself. So she ordered, and he agreed, that by Friday, everyone, including himself, would be wearing one. And this is pretty unusual here. From now on, every single weekday at 6 p.m., Commander Bovino will appear in Judge Ellis's chambers to report on the day's activities. So there will be some instant accountability if this happens again. He also needs to provide by Friday a list of every single person who has been arrested, not for immigration-related reasons, but for other reasons since this whole Chicago thing began on September 2nd. So, as usual, Judge Ellis does not play. And if I were Commander Bovino and I had to get grilled in front of her every night, I'd be watching myself. She is a tough one. I've been pretty impressed with her. Okay. Next, I want to introduce a new case, U.S. v. Stewart. Now, Kevante Stewart was sitting in his car in D.C. smoking a little something, which is legal in D.C., and in the words of Above the Law, bothering no one, when some of our fun new federal friends from the ATF who've been roaming the streets of D.C. Started harassing him and eventually arrested him. He was charged with trying to flee and throw away a weapon, but the grand jury did not buy it, and the federal prosecutor, Jeanine Pirro, once again couldn't get an indictment. So she started shopping it around other grand juries and ended up finding the indictment she wanted from a D.C. Superior Court grand jury, basically our version of a state court, not a federal court grand jury. And so, all proud of herself, she marched up to the federal magistrate judge with her D.C. Superior Court grand jury indictment, and Magistrate Judge Faroukwi about laughed her out of the courtroom. Now, Judge Faroukwi was himself a federal prosecutor for 12 years and a big law litigation guy who really knows his stuff, so he is not a slouch. And he just dismissed the case, saying that leaders of Pirro's office have tarnished its reputation and are routinely bringing cases that don't belong in federal court. Quote, "It's not fair to say they're losing credibility. They're way past that now. There's no credibility left." Well, yesterday, I headed down to see Chief Judge Boasberg hear arguments from Mr. Stewart's attorneys and from the U.S. Attorney's Office on why the federal court should or should not accept indictments from D.C. Superior Court grand juries. Now, both sides agreed that under the law it is acceptable, for example, to bring a case before multiple grand juries in the same court. I still don't totally understand that, but I do know it's legal. They also agreed that this special situation wouldn't have existed anywhere but D.C., where the laws are a little different, and our Superior Court isn't really a state court, it just plays one on TV. Now, there is also a disagreement as to whether a magistrate judge, who is not a full judge, but, they look like a duck and they quack like a duck, and they wear a black robe, so can they refuse to hear a case? And the government doesn't argue the point, but they also don't concede it. They wanted to keep it open in case they want to raise it on appeal. So here's the basic question. There's a law in D.C., 11-1916, and it says a grand jury serving in D.C. may take cognizance of all matters brought before it, regardless of whether an indictment is returnable in federal or D.C. court. But that law was written in 1970. When D.C. and federal court shared one jury pool. In 1986, they split the juries into two groups, and so one big question is that law just left over from way back when? In order to allow D.C. juries in 1970 to go off on a federal matter or a D.C. matter? Or does it imply that a D.C. jury can bring an indictment even if a federal court might also bring an indictment? Or does it imply that what happened in this case is allowed? Or some other shade of gray that I just haven't thought of yet. It's kind of hard to say. And obviously with the U.S. attorney having so much trouble getting indictments, they would love to have more grand juries to hit up. They'll just keep biting at that apple until it's nothing but a core. But we all understand that limitations provided by grand juries are there for a reason. And if ever there was a time for grand juries to have their moment in the sun, this is it. So to read grand jury statutes in favor of government overreach they're designed to prevent does seem to press up against some constitutional issues. But we'll have to see what the judge thinks. I'll let you know once he fills me in. All right, that is your Wednesday morning report on the past day in federal courts. Next week, we are back to oral arguments, folks, so start stretching those brains. If you haven't subscribed yet, please do it. It helps keep me running. Otherwise, keep watching, everybody, and I will keep going. Thanks a lot. Have a great Wednesday.